Mark Benton. I'm here with Sherry MacLennan. We're both from the Legal Services Society in British Columbia. I'm here really just to introduce Sherry, but I wanted to make a couple of comments before we get there. One of them is to echo a comment that Chris Bentley made this morning, that really in this kind of work are everything. And a couple of them that I wanted to point out that I think are quite important. One of them is for me, and for this project, there have been a number of people in this room, we might not be obvious, who have been directly involved in our being even aware of Rectilizer and Hill and others. Fred Zeemans in particular, and his work with the International Legal Aid Group resulted in introductions for LSS, in particular to the Dutch Legal Aid Board CEO, and in turn Hill, and those relationships helped us look at the Rectilizer initiative, and I had a chance to see that in its own development and think about how it would apply here, so that those kind of networks that are really about information sharing and knowledge are really central to how we're doing much of our development. I want to point to one other network that's at work here, and that's really David McKillop and LAO, and the leadership they've shown in putting this event together, working with Osgoode and their involvement, so that we could have this conversation really at a more national level about how we apply tech to making justice work for millions of Canadians. So thanks to you all for that. I'm going to say one more thing by way of introduction, and that is Sherry and I feel that at this stage in the day, it's time to unveil the baby, right? And so I'm not going to do too much introduction further, other than to say there are lots of areas that we can talk about once we've done the presentation. And for those of you who might be stuck for questions, you could ask us what we're going to do next. You could ask us about how the consortium is really working now that the other partners are offline. Right? You could ask us about what it was like managing the change with all the partners in the community when they saw this as a disruption and a risk. Right? Those are all pieces that play through. Some of them are more CEO kind of concerns. Some of them are more profoundly operational. And we were happy to talk to any of those. And we're also happy to talk about what we have in mind for an evaluation, what we're looking at, how we're going to look at it. So without saying further, I'm going to turn it over to Sherry, who will unveil it all to you.
All right. So Mark said, I'm going to give you a quick demonstration. I'm going to highlight some features that I think are kind of neat about the site and tell you a little bit about what's going on with the site that you wouldn't know just by test driving it yourself. And so with that, I'll begin. This is our home page. Just learning how to navigate this new laptop. Down here, you see the areas of law that we cover. We pick these areas of law based on research that our Law Foundation and our LSS Research Fund commissioned to identify gaps, high priority needs, and high priority audiences. And as well as we did an environmental scan to see what other public legal education providers, including our government, were doing so that we weren't going to be duplicating anything. And one of the things we found was that there was really a high need for help with wills. And so we developed a pathway on wills where people can make their own will. One of the interesting things we found working with wills lawyers is, contrary to what you may believe, there's no such thing as a simple will. Nonetheless, we provided instructions on how to do a will, and what people will get after they do a question and answer process is a template for a will, but it's more than a template. It's customized to their situation. It's one of 22 variations, and it's not a fill-in-the-blanks will. In fact, it is a simple document assembly using questions and answers like TurboTax that will generate the will at the end of the pathway. And this has actually been our most popular section of the site to date. I also want to show you a a little bit on our abuse and family violence site. We worked collaboratively in many different ways in constructing this site, and we worked in particular for this pathway with women's groups. And they told us the most valuable thing we could do is create a checklist for women who needed to do safety planning. And so that's what this section is about. They also told us it would be very important that there be some protection in case someone walked in, you know, the drunken abusive spouse while they're on the computer. And so for this section, we do have this quick exit that'll quickly take people to the latest news on CBC and Google. Provide some protection that way. If someone walks in, someone can make a quick escape. And otherwise, I'm not going to go through that pathway. What I am going to go through, we'll do this maybe later, is our separation pathway, which is our second most popular section on the website. It'll give you a good feel for how the pathways operate. And what you notice about the pathways is we start off with chunks of information on the left side of the screen and toolbars on the right, because what we're trying to do throughout the site is link people to in-person services where they can go, or at least where they can talk to someone on the telephone and connect them with free services wherever possible, because our target audience is low-income people and people who can't afford a lawyer who would otherwise have nothing. So I'm going to go through the pathway very quickly. I'm not going to read you the chunks of law about it, but I'll let you know what I'm doing as I go along, because otherwise it would take too long. So my fake spouse, Larry, and I were married. And it's going to be a little bit of information about separation and divorce. We've taken what we call a bite, snack, meal-sized legal information, and so the pathways are the bites of information, just introducing legal concepts to the user. And yes, Larry and I have children together, and they are under 19. We've got a little blurb there that tells us disabled people can have special considerations. A little bit more information about our responsibilities when we separate. Look, because we indicated we had children, I've got a section coming up on child support to give me just some bare bones information. And now it's asking me about financial decisions. And to keep things simple, this probes spousal support, business opportunities. I'm just going to say our situation is not listed here. Still gives me some information about spousal support, the law in Canada. You notice we've used the phrasing, Canada has no-fault divorce law. Yes, that's very American, but working with people who are self-representing, that's the language they know and understand. And so that was a deliberate choice on our part to use what could be unconventional language, but because it resonates with the audience. Okay, so did my spouse and I rent or own our own home? Well, if I said we own our own home, continue. Gives me a little bit of information about entitled to my share of the property value at this point. However, Larry and I live in Vancouver, so not surprisingly we rent. And so instead of that information, you see the pathway is tailored, and it's now giving me a little bit of information about lease or rental agreements. It's asking what kind of stuff we had. Well, we had bank accounts, possessions, and that's about all. There's some information about basic property rights. Oh, did we take on any debt? You believe it. We live in Vancouver. Okay. Information about dividing debts. Now we have some questions designed to help assess whether I should be continuing to do this on my own or maybe get some help. Okay, so how's communication going? Well, I wouldn't be here if it was going well, so poorly. Okay, some information about options other than court at this point. If I'm thinking I really want to take that jerk and hammer him, and I start reading a little bit about mediation, and the trial costs almost $40,000 for 2 days. Oh, mediation, $3,000, maybe that's something I should consider, right? Okay, that's interesting information. Okay, do I think I can work with Larry to resolve issues? Well, at $39,000 for 2 days, you know, I think I'm going to try and work with him. So this page now means we've reached the end of the guided pathway. This is what we call an action plan, and every guided pathway will end in an action plan. It can be downloaded into a PDF document and printed or saved for the person. I'm just going to go through it online here. It begins with the summary tab, which summarizes key information that was gained from my answering the questions in the pathway. Then takes me to the read first, which is to give me some background information, tell me what my options are, and links to other information. And so one of the things we have here is coping with separation. Let's see where it is. Oh. Because we heard working with the self-represented people about how significant the emotional components were of going through a separation, and we really wanted to take a holistic approach towards meeting their needs, we thought we developed this handbook specifically to deal with the emotional aspects. And I'm just going to quickly scroll through it because it highlights the very visual way we're trying to present information. We want it to be engaging, easy for people to absorb. So you get the picture from that. It ends with resources where people can get more in-person help. Sliding down here, you don't need to go to court. Again, we're trying to be more visual. We've done a number of infographics specifically for this website. We're using them as posters as well in our promotional activity. So we're flagging, little stars to indicate where there's free resources, explanations as to what they are. Kind of a fun and different way for people to absorb information. I'm just going to scroll down a little bit more. In the mediation section, we also developed a infographic for mediation. Again, another different approach. One of the things we were very aware of was Julie McFarlane's work out of the University of Windsor in the National Self-Represented Litigant Project, where so many of the people that were interviewed said, nobody told me about mediation. I didn't know what it was. I didn't know it was an option for me. So you'll see throughout MyLawBC lots of references to mediation and those resources. And one thing that's been interesting in the last week, we're actually contacted by the Alberta Department of Justice and Dispute Resolution Office who want to adapt this particular graphic for use in Alberta. So we're going to collaborate with them to ensure that that can happen. Tailor, of course, with their own statistical information. And then another way we're collaborating, we're making use of other people's videos. For example, our Continuing Legal Education Association video about mediation. So that's the read first. The do now tab, the key feature here is for people to figure out if they can work together and whether they'll want to use the dialogue tool on MyLawBC. And so here's where we get into the snap approach to information. The dialogue, the negotiation toolkit, just going to see if I can bring the bookmark up here. Okay, let's jump around a bit. Oh, what have I done? Let me just go back. There we go. The negotiation toolkit, like the coping with separation, is intended to be very engaging, easy to absorb information. So as a user who's answered all the questions, you're going to get one negotiation toolkit tailored to your situation. And this is where we have the snack size information. So it's got more in-depth information about each of the legal issues you identified in your pathway. And so in the back end, which you can't see, we've got 19 other negotiation toolkits. But you only ever see the one that contains the facts that are relevant to your situation. And the toolkit itself is an example of another collaboration. J.P. Boyd, a very well-known Canadian family law lawyer, has an excellent resource online on family law. It's on a book format. Let you have a look at it. It's a great resource, and it's also a wall of words. People find that daunting. We're trying to respond towards making things engaging and tailored to what they need. And that's what we think we're doing with our 19 different versions of the toolkit. I'm not going to go through this in any more detail in this section because it does talk about moving people towards the dialogue tool. The do next stage focuses on what someone would do after they've used the dialogue tool, and I'll be showing you that next. It's the negotiation platform where people can generate their own separation agreement. So this do next stage is focusing on post-agreement, and it's trying to connect people with legal services, get legal advice, take your time, giving them that kind of information. The last tab on a pathway is always where to get that in-person help. So we're integrating that and provide a lot of different resources. It's also tailored based, again, on the questions and answers in the pathway. So because there were children, we've got information about child support officers. Because I indicated I had debt, it's got resources for credit counseling. Because I said I was a renter, you've got resources for renters. Again, because there were families, we've linked to, with children, one of the other resources we included is our own Family Law BC website, which is really your meal size information. But then we've also included what's really a very neat site from another one of the BC PLEI providers aimed at children and teenagers whose families are separating. So we've tried to provide different resources. So I'm going to move on to the dialogue tool. And so this is the negotiation platform I was telling you about. For the purposes of the demonstration, Larry and I have already created accounts. We've been working on our separation agreement for a while. So I'm going to go in as a returning user, so you don't have to watch me type. I've already logged in. Now this will look a little familiar from what Moritz was showing you. You can see how we adapted the RectWiser technology, particularly here, and this is the Modria dispute resolution platform. So what we have is all the issues that were identified during an intake. So because this is completely private, it began with an intake, which again was a series of questions that you would have seen similar to the pathways, and that identified our issues, which are then reflected here. You can see on this top line, separation agreement at 67%. That means Larry and I are 67% in agreement. We're that close to being done. What we have down here are the issues to navigate under the communication heading. Back files. Here's where some of the demographic data is stored from doing the intake. So you can see we're married. And how it works, I went in first, I did my intake, answered all my questions. Then the system would send Larry an email that looks like this. MyLawBC says, Dear Larry, MyLawBC. And I'd invite any of you to play around with the dialogue tool if you like. Just ask you, use as a last name MyLawBC, because that's how we're trying to sort out user tests. Anyway, it welcomes Larry, lets him know what's going on. Up front, everyone is told, discuss this with your spouse first. Don't surprise him with an email. So that shouldn't have been a surprise to Larry. Okay. So here's our demographic data. We're married, basic information, all recorded there. During the intake, We also are asked questions to reflect on our situation and record what our initial ideas are for a separation agreement. And then that's how that first exchange of views happens. And so the first section is communication. What can you do to make sure you listen to each other? What can you do to, so it says, what can your spouse do to make sure you listen to each other? I'm saying he should let me speak. Larry says she should shut up. Well, that didn't go down well, so I took advantage of the chat feature down here, and I said, great way to get the process started. Fortunately, Larry didn't respond, and we cooled off and were able to move on. So in the make decisions section, we move into the actual, what does our separation agreement look like? And as you can see, the system, based on the information we gave on our intake process, starts to develop draft clauses that we can customize to our own situation. So in this case, I've left in some lines here, so there was a blank to indicate how many days it'll take before we respond to each other. And so we're going to agree that 3 days is a reasonable time to respond to each other, and then we're going to use the MyLawBC system as our primary means of communication. So here you've got S for Sherry, L for Larry, he's agreed, S open, but now I'm going to agree to this. And so the system now has marked that clause as agreed. Moving on to the next question on dispute resolution. So we're agreeing we're going to try and talk things out, go to mediation, but how are we going to pay for that? Well, we've filled in the blank in proportion to our income. Larry's agreed to that. I think that seems fair. So I'm going to agree too. And you'll notice how the percentage here is changing from 67, we're now at 80% because we've been moving along. You look at these top sections when they're completed, white ring and a little check mark beside the section to let you know how your progress is. I'm now going to the children section. And again, what's in the best interest of our child, Sasha? We've agreed to 2 weeks on, 2 weeks off, or we're about to agree to that. Very conveniently, Larry's agreed to everything. There you go, we're moving right along. So now I'm going to move to the special days issue, which is, as you can see, who's going to spend Mother's Day, Father's Day, how are you going to divide summer holidays? I've left all the blanks in there. Again, if you were actually doing a real agreement, you would get rid of those and just delete them. And then you end up with a professional looking agreement at the end. As I move through each section, because I'm going through quickly, you may not have noticed, but we've got different tools on each side tailored to the issue that we're dealing with. So because we're talking about children here, we've got some spousal support calculators and information on where they can get in-person help from our Family Duty Council and get advice, and how they can contact our family law line where they can get up to 6 hours of advice and coaching from a lawyer. So again, it's that idea of integrating services where they're relevant and where people will see them. We're also linking, again, a bit more of that snack size information. Oh, guardianship, remind me what that was. Again, we've got a bit more information they can access on the right side of the toolbar. So now you can see we're done the children issue. Nearly done. Got another example of the chat and how we're negotiating. That makes sense to me. Glad you agree. That can happen at the same time or at separate times. Moving over to the income section. This is my last item to agree to. Here we're agreeing no spousal support will be payable. Again, so then on this side, you get information specifically about spousal support, as well as a link to the one spousal support calculator. Now, if you go back up here, you'll see everything's checked off. We've actually dealt with the home issues, the property and debt issues, so we can have a look at the separation agreement now. Internet seems to be going a little slowly. So this is a preview clause by clause before we finalize if there's anything that, want to make any last minute changes. Larry would be alerted to any last minute changes and it would be open again. But once we've all been through it, then it's locked. So this is what the separation agreement would look like. It's downloadable. There's a space at the end recommending for them to get legal advice, suggesting they consult with a lawyer, letting them know that they can get independent legal advice, and then space for signing. And so that's the basic overview of the site. What we're excited about is that it's got potential to do a lot more, as we've seen in the Netherlands. They've added mediation, legal advice. There's the potential for arbitration. The platform that Motories provides has got a lot of opportunities based on our budget and our resources at the time. This is as far as we're going. We also wanted to be a little bit cautious and see what the Netherlands was going to learn from their experiment with online mediation. And we're excited about what the future can hold. So,
thanks, Sherry. For those of you online, #WiredJustice is the way you can get a question to Sherry or me. But I want to start on this in part because as we entered into this enterprise with MyLaw as part of our public legal information business. Legal Aid in BC has had a strong public legal education information presence since it was formed in 1979. It was one of the few areas that got no cuts in the 2002 big cutbacks at LSS. And these days, this work and all our other public legal information education work is funded with non-government revenue, so it's in some ways protected. That's typically foundation revenue or interest-based revenue we develop otherwise. But as we talk about this and as you see it, this begins to look a lot like almost any legal aid interview you do, right, in terms of collecting information and trying to deliver the appropriate professional information to this. I think the other thing you'll notice if you do any public legal education information work is the amount of white space on those forums in that whole area, instead of Sherry put a wall of words. So Sherry, what are the big things you've learned from this?
I think one of the biggest challenges is, again, achieving that culture shift, because when you're working with lawyers, we're so, we have so much knowledge and we want to share it all, and we want to share it all now. And people, unfortunately, don't want that big download of information. So again, we really learned how important it is to deliver the information in small pieces and take the time and work with the lawyers and other service providers to make sure they understand that before you start working with them, because that's a very significant thing for them to adjust to. The other thing that we learned is, although we had a vision to be very collaborative, and we were able to be fairly collaborative with other PLEI providers, the idea that we were doing something so different was really seen as disruptive in our environment, and there was a lot of, I think, fear and worry about how it would disrupt other services, especially because we've got an excellent portal, which is like an online library in British Columbia for public legal education information, and a lot of people had trouble visualizing the idea. What is this going to look like? Is this just another way of pulling, the brochures off the shelf? And we see it as so much more than that, because we think people are empowered to take the next steps. That was really our goals, to make sure, and that's why we've got the tagline, my problem, my solution. We want people to be able to take those next steps to actually get results, whatever their situation is.
One of the things that really surprised me as we moved through this process was how disruptive it really was to people. It's disruptive for a number of reasons about how we think about legal aid service delivery now in BC. But in this case, as Sherry was saying, there were people who felt threatened, and they in turn went to our funders and said, you know, what are they doing? This is just completely crazy and a waste of money and just duplicating everything that's already been done. As you've just seen it doesn't duplicate anything. But so Sherry and I had, along with our board chair and board members, had several discussions with our foundation funders because they were very unhappy about how this was unfolding, even though this wasn't a special grant or anything else. In fact, the money we used to seed the startup for this was actually a reduction in funding. They gave us a year's notice on a reduced funding. We said, fine, we'll take that money and use it. That also upset people, that we'd actually, once the funding was announced, we'd actually start something. But that's sort of part of the culture of the organization a little at LSS. I think that we've learned too through all of this, and I think Sherry's carried the brunt of it, is that change management in this kind of initiative is really important, particularly out in the community. Sherry moved quite quickly to a mode where, you heard her talk a little bit about this, where we were engaging all kinds of people in both talking about needs and in talking about how to answer those needs. I think Colin mentioned that on the comment earlier. It's not that that's a rare thing for us to do, but I think we did it at a level that was unusual, even for us. I don't know if you have comments on that, because I think that you were having to design process on the fly.
Oh, we definitely were, you know, especially, you know, the early developmental scrums were so new to everybody because we'd never developed publications or websites in this fashion before. And, you know, we invited a wide range of people to participate. And again, we were asking them to give them other time. We'd give honorariums where we could. But it was interesting, you know, not everyone that was invited attended. But then later they would find out what happened and suddenly they wanted to be a part of it. So we actually had to then do follow-up meetings to get those people that felt left out involved, because they really wanted to be engaged in the process and make sure that the outcome was good for their particular constituency, whether it was, you know, victims of violence or people needing family justice counselor services or whatever the case may be.
Sure, another issue that came up in the earlier conversation was about how's the relationship work with Modria and with Hill. And I know you were asked with them both on the line, but
well, they have been great people to work with. I have to say, they've got really charismatic, fun people to work with, and so we have a good working relationship. But I think we do have some growing pains. You have to get up awfully early on the West Coast to Skype, and that's how we've had most of our meetings, so that's been a bit painful. But aside from that, there are some growing pains when you're working in a three-way collaboration. And so how it works technically is we contracted directly with Hill, and Hill subcontracted with Modria. We had legal advice that would be the best kind of arrangement, most standard in this kind of a software as a service arrangement. So it's how do you figure out your priorities as a consortium on what you want to develop? And so it's interesting to find out how much you have in common with things like the Dutch Legal Aid Board, and how they find out, you know, just like we do, agreements don't last because family circumstances change. So how do we help that? And so as a result, everyone's prioritized an aftercare component, and then Hill and Modria work to implement that. One of the things we found, again, that's different for us, because all our other websites we've had full control over, so we can go in and mess around with them and update them whenever we want. Now we're working with other parties, so we've had to develop protocols, and we're still in the process of finessing those for a timely response. We have broken links. We want them fixed pretty quickly, not 3 months from now. And so we do have some challenges like that when you're working with two different partners.
And do you want to talk a little bit about the consortium that involves the Dutch Legal Aid Board and Relate?
Yeah. So the consortium, Morris mentioned that, and what it is based on the agencies that are adapting the Rectwiser technology. And it had just such an interesting concept behind it to us, because this is where the benefits of scale come in. Modria, who of course is providing the service, providing the upgrades to the platform, maintaining the security, they need to be paid for that service. And the Legal Aid Board has instituted user fees, We've done kind of a licensing fee to pay for that, so we don't have to pass any costs on right now. But the idea is the more people participate on a per capita basis, those user fees go down. They're not the same for everybody. So Modria is not making more and more money. It's like a flat fee that gets divided among those that participate. So that was like a really refreshing approach to public-private social enterprise kind of arrangement.
Yeah, David. This is David McKillop from Legal Aid Ontario.
Were there any issues at all from a public procurement point of view in contracting with a Dutch body?
We have laws in British Columbia that prevent us from discriminating against particular national groups. But there are issues around that, and in fact, do you want to answer that? Because we have our own policies about tendering, and we have a bit of a story about how we did requests for proposals. Do you?
We did. We actually had, checked with a few interested vendors, talked about what we were going to be doing. They sounded interested. Then when we did a request for proposal, we were really disappointed with the results that came in, and so disappointed that we thought, well, there's this Hill group, maybe we should find out more about them and what they're doing and what it would be like to work with them. And as a result of that process, we decided to come back and make an exception, as is allowed under our policy, to the regular procurement process. So we did direct contract with them. The other thing that offered us a lot of comfort is that Modria, although it's California-based, it actually provided services to the BC government for many years in terms of online dispute resolution. So they're well familiar with our needs for confidentiality and privacy requirements.
And we hedge against the euro. So we've had to do a number. It is more complicated.
Sure.
But Sherry hasn't talked to you about how we worked through all those complications, because what she was able to secure in terms of the arrangement with Hill and Modria wasn't where everybody started.
No.
Right, and that actually delayed the project for some months, working that out.
Well, that was something that was interesting to us, because Hill, having worked with the Dutch Legal Aid Board, we had, I guess, wrongfully assumed that they would have very standard formal contracts in place, but in fact, their arrangements were very informal, and I suppose it's because they had a close relationship with Dutch legal aid. And so we had to retain counsel and get advice for ourselves. We weren't experts in standard software as a service agreements. And so it took considerable negotiation to get an agreement, not on the main things that we wanted to accomplish, but all the little what-ifs that are important when you're doing these kind of contracts. So that did take us a couple of months to get that worked out.
So, yeah, it was a little bit more complex than, quite a bit more complex than we had anticipated when we went into this, because we thought it would all be about building. And in fact, a lot of it, appropriately, was about defining the relationships and the risks.
We heard from David Bonebreak this morning. He talked a lot about the scalability of the websites and the programs that they're funding in the States. I'm wondering what sort of opportunities are there for scalability with MyLawBC in terms of the other legal aid plans across the country?
I think with MyLawBC, because it's a three-way arrangement, the best way, I think, for scalability would be to explore further with the Hill organization on how we could do that, because their platform partnership with Modria is designed to be scaled. So I think there is opportunity, and I think as legal aid plans, we've got a lot of opportunity to share content development, in the knowledge we've learned, for example, from doing scrums and developing change management pieces. We're certainly willing to collaborate with others. It's just, I think, a matter of finding the right platform and people being satisfied as to what is the right platform.
Do you want to talk about your reservations about the platform? I think you've touched on maybe one or two, but
I think for us, the primary reservation all along was giving up control, because we've always had that total control. And I think this is a point of tension for us right now in terms of working out how much access to the back end we can have. And we originally intended that we would be able to go in and do our own minor updates that wouldn't affect the configuration. But they do have some concerns right now with how their back end is set up, that we could inadvertently, cause a downhill impact, which nobody wants, because then Dutch legal aid could be affected, and so could relate to the UK. And so one of the things we're discussing with them, and that we think the direction we're moving in, is we may do the back end of pathways ourselves and rebuild them, because we've learned so much on how to do that, and that way we wouldn't have to be dependent on Hill for that pathway updating piece.
David, do you have another question? No.
I wanted to ask about the timelines, so from like RFP to product delivery, production, how long?
Well, the timelines were about 2 years, but we actually were really only working on the project for about 18 months. And part of the reason was we spent a lot of time connecting with the other public legal education information providers, trying to share our vision, find a role for them, how they could participate, did they want to participate. They certainly had a lot of input into what areas we developed, user testing some of the pieces. In retrospect, we definitely spent too much time, I think, trying to build those relationships, because, as Mark indicated, they kind of view this as very disruptive. Crazy old LSS, what are you doing? Why should we be involved? And, they had a lot of hesitation about it. So that was definitely a challenge. And then, as mentioned, although we very much were well aligned with Hill on what we wanted to accomplish, how we were going to accomplish it, what the fees were, it was the risk management piece that took far longer to negotiate the contract than we'd anticipated. So that took a lot of time. And we weren't getting started with the building until we had nailed down the contract.
I think I've got about 1 minute left. We've got an evaluation that's in planning. Like every other evaluation we do, it will be published. We think this will turn out pretty well, but we're going to be looking at how this actually benefits people, how easy it is to use, what they like, what they don't. It makes. We're looking at it from what are sort of, I think, some fairly obvious objectives. How helpful is it, to perhaps less obvious ones of how well does it help people like better identify the legal problems they're facing, and how much does it build capacity. So that'll be out there. Before we have, those of you who watch us a little bit will know that we have had some bad evaluations. We did kiosks once, right? That we didn't do for very long after the evaluation came in. But this one's going to be interesting. I think it's very much learning. Heidi Mason's really been a champion within LSS of saying, look how we could use all these things to make the rest of the service better by having clients be better informed when they're meeting with their duty counsel lawyers, by LSS being able to get information in advance to provide service. And we've got private lawyers who are looking at this, who are sort of in our sphere of influence, who we know are looking at how they can build it into their practice so that they can serve their client, either their legal aid clients or their non-legal aid clients more effectively. Thank you so much.